I want to get into what is commonly described as rules of interpretation of statutes. But let me strike a note of caution over here and fast forward a little bit to judgment. So these rules or aids to interpretation of statute are not really rules in the doctrinaire sense of the word. And that was something that was reminded to us by the English judgment, which is quoted in my note. Judgment in the summary of cases, which is number 1 in the case of Maunsell versus Olins. And I'm not reading it out, but I'm drawing a reference to it because it's important to keep this in mind. What the English judgment tells us is that these rules are really aids. And it says that we cannot look at them as our masters, but we look at them as our servants, and they have no binding force. So keeping this in our mind, let me start beginning with some of the key interpretative criteria or rules or aids to interpretation of any statute. And the first of them is going to be the literal rule of interpretation. I'm not reading from my note, but what I have done in my note in the introductory section is to very briefly, under different subheadings, describe the literal rule of interpretation. Now, I want to explain something over here and explain this through the trend in the judgments that we have seen. There was a time about 100 years ago when in the English courts, the courts approached the subject of interpretation of statutes in a more hierarchical manner, which is that they viewed these rules as having some kind of priority inter se. And at that point of time, it was the view or the prevailing view that the literal rule of interpretation, which is that you look at the statutory provision which is being considered by the court, and if the language of that provision is grammatically plain and clear, then you must interpret it in its ordinary sense. And that is really the best and the only indicator of what legislative intent is. You just look at that provision. It was a more funneled approach to interpretation of statutes. And that was the approach that had currency at that point of time. Therefore, that was an approach which gave primacy to the plain grammatical meaning as being synonymous with legislative intent or the legal meaning. Grammatical meaning is how you would understand those words as words of English. The legal meaning is how you would understand those as words of English, but within a certain legal framework or legal context. But at that point of time, when the literal rule was more the rule that was given importance than it is perhaps today, and I will show you through judgments where this shift has taken place, the literal rule was if that section or that subsection is clear and unambiguous, then the grammatical words mean what the legislature intended. And perhaps that is really brought out in, if I can, just read out one passage to you or draw your attention to one judgment which is in my note, which exemplifies this approach, which is in Jones versus DPP. And in Jones versus DPP, it would be in the introductory section of my note. This was the approach to the literal rule. And this is what Lord Reed said. It is a cardinal principle in all statutes that you may not attach to a statutory provision a meaning that the words of that provision cannot reasonably bear. If they are capable of more than one meaning, then you can choose between those meanings. But beyond that, you must not go. In other words, the literal rule in its formulation said, if unambiguous, one meaning, you will not travel beyond the literal rule. And you will look to the other aids to interpretation only if there is an ambiguity in that language. Now, This formulation of the literal rule is also what has been followed in some of the judgments in India. And I'm going to take you through some of those judgments now and tell you what was the controversy at hand over there. And I'm not for a moment suggesting that those judgments were incorrectly decided or that I disagree with the judgment. That's not the point I'm trying to make. The point that I'm trying to make is to explain to you in the context of a given controversy how the literal rule in its stricter formulation was applied by the courts. Now, the first judgment, which I think makes good this point, is an interesting case before the Delhi High Court of Mathew Nedumpara versus Fali Nariman. Now, you might ask, how did this case come about? And if you will look at the summary of cases in my note, the provision that fell for interpretation over there was Rule 6 of the Bar Council of India rules. And Rule 6 was a rule which essentially said that a family member will not practice in the courts if another family member is a judge or a member of the tribunal of that court. But the explanation to that rule, assuming there was any ambiguity in the rule itself, defined what court meant for the purposes of that rule. And it said, for the purposes of this rule, court shall mean a court, bench, or tribunal in which the above mentioned relation of the advocate is a judge, member, or the presiding officer. So it was very clear. And this is perhaps the plain vanilla example of a literal rule. And the Delhi High Court said that the court, for the purposes of Rule 6 of the Bar Council rules, cannot mean the entire Supreme Court or an entire High Court. It obviously means only that bench on which the family member is a presiding judge. So this is an illustration of the literal rule. And in this judgment, the court in that case relied upon Supreme Court decisions, which I am going to make reference to, which followed the trend in England of about 100 years ago in attributing hierarchy amongst the various aids to interpretation or rules of interpretation. And those Supreme Court judgments are also referred to in my note. In the summary of cases, they are also there in the table of cases. And that is, for example, in Raghunath Bareja, where the question was, as Justice Sinha put it, of hard facts and following the law regardless of the consequences that follow. That was a case where the Supreme Court in the year 2007, and I believe somewhat inconsistent with Supreme Court judgments of that period and prior to that, clearly took the view that if the plain meaning of a statutory provision is clear, then you must, as a court, as an interpreter, follow that plain meaning alone, and you cannot have, even in the first instance, or certainly not at the first instance, recourse to other rules of interpretation or aids to interpretation, like, for example, understanding legislative history or understanding background, understanding context, understanding mischief. And they, therefore, the Supreme Court in Raghunath clearly gave this kind of prioritization to the rules. And they said that in paragraph 40. And this arose in the context of a case where a bank had filed execution proceedings against a debtor in a high court for the purposes of executing a decree that it had obtained. But the bank, being negligent, allowed those execution proceedings to be dismissed in 1993. Then all bank suits were transferred from the High Court to the DRT. And the transfer provisions, which I've quoted in my note, which is section 31, was a transfer provision which applied to proceedings that were pending on the date when the DRT was notified. Now, the bank had allowed its execution application, which had been filed, to be dismissed for default, and it had been recalcitrant or negligent on more than one occasion. The High Court took a benevolent view of the transfer provision and felt that no matter what the negligence of the bank may be, surely we cannot allow a, a defaulter to get away on a technicality that on a particular date the execution application stood dismissed. What the High Court did essentially was to say that even if the execution application had been filed before that date and stood dismissed, and that date has come and gone, we will exercise powers, inherent powers, and expand the real intent of the statute and allow even an execution application which is refiled after that date to be transferred so that the bank can realize its dues, legitimate dues, before the DRT. And the Supreme Court said no. And it was in that context where the Supreme Court very resolutely, even though it acknowledged that wholly inequitable outcome as far as the bank is concerned, said literal rule means literal rule. Section 31 says what is going to be transferred is what is pending on that date, no more, no less. And that's how it applied the literal rule. And it applied it in a way where it expressly said that you will not look at any other aid to interpretation if the language is plain. It cites an English judgment in Gundry versus Pinger or Pinniger, which went so far, and it's no surprise that the judgment of Gundry versus Pinniger was a judgment of some time before that. It wasn't the current view in England, but it cites a judgment of Gundry versus Pinniger, which went so far as to say that the courts will interpret a statute as closely as possible to the literal rule, and any departure from it would amount to judicial indiscipline. So this is how far, and the Supreme Court and the earlier view in England made no bones about the fact that this is rule number one, it gets pride of place. So this is really, my friends, the literal rule. There are other expositions of the literal rule. So the other judgments on literal rule are to be found in my note. And I only want to highlight one more of them as a pure example of literal rule before I move to a next category of judgments or principles. And that's in a very interesting judgment of Justice Nariman in the case of Alka Chandewar, which is to be found at item 7 of my summary of cases. It's also there in the table of cases. Just as a quick digression, what I've done is the table of cases gives you the relevant paragraphs and summarizes or paraphrases what the judgment held. The summary of cases is only intended to give you a quotation of the statutory provision in question so that you can actually read the provision and understand what the interpretative controversy was in a given case. So this was a case where the question was, how wide are the powers of contempt of an arbitral tribunal under section 27 subsection 5 of the Arbitration Act? Now, the Bombay High Court in this case took a very conservative view and was influenced in its decision by the placement of 27.5. If you look at 27.5, section 27, it deals with court assistance in taking evidence. And whilst subsection 5 deals with a situation of contempt, the Bombay High Court was colored in its interpretation of subsection 5 by the heading and the placement of the provision. When the matter traveled to the Supreme Court, Justice Nariman fell back on a plain and literal meaning of this as an aid to interpretation. And that is what he applied predominantly when he construed 27.5. He said, we have to forget about where this section is to be found. We have to look at the language, and let's read the language together. Does it admit of any ambiguity? And this is what it says: persons failing to attend in accordance with such process, or making any other default, or refusing to give their evidence, or guilty of any contempt to the arbitral tribunal during the conduct of arbitral proceedings, shall be subject to the like disadvantages, penalties, and punishments by order of the court on the representation of the arbitral tribunal as they would incur for the like offences in suits tried before the court. And Justice Nariman looked at this and said, it's as plain can be. Which part of this subsection says that it applies only to witnesses who give evidence? On the contrary, the language is any other default, refusing to give evidence, comma, or guilty of any contempt. And therefore he said, so what if the placement is wrong? So what if the placement is misleading? This is the literal rule. This is the literal meaning. This is the plain meaning. This is the grammatical meaning. And that is all that we are going to apply for the purposes of understanding it and reading it widely, and thereby conferring more powers on the arbitral tribunal to take action for contempt. Now, therefore, this category of cases, particularly the Delhi High Court in Nedumpara and the Supreme Court judgments cited within that, use and invoke the plain meaning or the literal rule, but give it primacy. That's not really how many other judgments and courts have used the literal rule. And perhaps, if I may say so, and introduce my own opinion on this, the more correct way of understanding the literal rule is to understand it as undoubtedly an important aid to interpreting legislation, but without approaching it as some kind of sacrosanct or number one rule to interpretation. The next category of judgments in my note, which really begin from serial number 8 onwards, in the table of cases as well as in the quotations, are examples of cases where the courts looked at the plain language, the plain meaning, and without coming to the conclusion that it was ambiguous, simultaneously looked at other interpretative criteria as well. But then in the ultimate decision of those cases said, we are going to go with the plain meaning of these words because we are not able to find any overwhelming contraindication when we look at context or when we look at legislative history, when we look at mischief, when we look at various other provisions from the point of view of harmonizing an act as a whole. And another way of therefore approaching the literal rule is this, that, and this is the more balanced approach to a literal rule interpretation, which is that the plain language and the grammatical meaning of words is undoubtedly the starting point of interpretation. It is undoubtedly important. And one way in which you can approach this is the way Benyon puts it, and that's part of the introduction in my paper, which is that the interpreter will always look at the plain language as prima facie being synonymous with the legislative intent, but prima facie. Yet, it allows you, without necessarily having to look for ambiguity. In other words, even if the plain language is unambiguous, in the balanced approach, you can still look at other factors to see if there is any overwhelming reason why you should avoid a plain language interpretation which may prima facie commend itself to you and choose or opt for what is known in legal terms as a strained interpretation. That means an interpretation which is other than the plain language. And these line of judgments give importance to the plain language, but they simultaneously look at other factors to conclude that those other factors do not militate against the plain language, or those other factors do not throw much light on the matter at hand, in which case we must go forward with the plain language. And this more balanced approach was perhaps first expounded, not first ever, but I'm saying amongst the cases that I have, and it's an old enough case, as far back as in 1857, in a case where the court was in England was concerned with the interpretation of a will. And the plain language over there, which ultimately is what the court applied, was the sentence that the beneficiary named would be inherited in the event a conjunctive event occurred, or in the event that he shall die under the age of 21 years and without issue, which you will find as part of the court. So the court said that the language is very plain. But yet, in this very important judgment, which is referred to in very recent judgments of the Supreme Court, it's not as if the court, even back then in 1857, said nothing else can be looked at. The cautionary note struck when reinforcing plain language was, unless there is something repugnant in a reading of the will as a whole, or unless there is a clear indication that this is not what this particular sentence was intended to mean, we will apply the plain meaning. So there was an avenue opened even in 1857 to deviate from the plain meaning. Let's look at one or two more examples where the court has applied the literal rule, but at the same time taken into consideration other factors. Another very good example of this is judgment of Justice Lahoti in Harbajan Singh versus Press Council of India. And I'm going to also, after I explain what the context is, request Mutahar to put this up to share the judgment. Here the issue was, as the title itself suggested, an interpretation of the Press Council Act. And what the Press Council Act had as a stipulation was that if you were a member who was part of the council, then as an existing or as an incumbent member, you could only be renominated once more. That means at a stretch, you would be renominated once. And thereafter, you could not be renominated a second time. And let's look at the language which fell for interpretation before the Supreme Court in section 6, subsection 7. It was a one-line provision. A retiring member shall be eligible for renomination for not more than one term. So there were two important plain expressions used in this short section. Retiring, please note ing, shall be eligible for renomination for not more than one term. Now the controversy in this matter was that the petitioner had previously, at some point of time in the past, already served 2 terms. He then retired, and then he put his hat in the ring or filed his nomination to be appointed or elected to the Press Council for a total of a 3rd term. But keep in mind the fact that the 3rd term was not whilst he was an incumbent member. It was 3rd overall, but there was a gap in between. So the question was that, does section 6 subsection 7, the object is free press, and I would imagine that somewhere within this object is the idea that there should be no monopoly of people who are constantly occupying positions in the committee or in the council. But the controversy was that, does section 6 subsection 7 per se prohibit a 3rd term, or does it simply say that whilst you're an incumbent, you can be renominated once and then you must step down, and perhaps at some point of time in the future, can you be re-elected again? And Justice Lahoti, in what I think is a very, very balanced judgment, and for anyone who wants to cite law or perhaps dive deeper, in a very balanced judgment, of course starts by a plain language interpretation of section 6.7, or what we will call the literal rule. But at no point of time does he say, I'm giving it primacy or I'm giving it importance. He recognizes that you have to, in the same breath, look at other interpretative criteria. And if you could just permit me to read some parts of this judgment to make the point or to illustrate the point that I am making. If we can go to paragraph 7 and 8 of the judgment. Clearly, the language of subsection 7 above said is plain and simple. There are two manners of reading the provision. Read positively, it confers a right on a retiring member to seek renomination. Read in a negative manner, the provision speaks of a retiring member not being eligible for renomination for more than one term. The spell of ineligibility is cast on quote unquote renomination of a member who is retiring. The event determinative of eligibility or ineligibility is renomination, and the person by reference to whom it is to be read is a retiring member. Retiring member is to be read in contradistinction with member person retired sometime in the past, and so would be called a retired or former member. Re means again and is freely used as a prefix. It gives color of again to the verb. And then he continues. Then in paragraph 8, again in pursuance of a plain language approach, he analyzes the words. The provision is cast in the present tense. A retiring member is ineligible for renomination. Not more than one term qualifies renomination. The words retiring used in the present tense and renomination speak aloud of the intention of the legislature. If the word retiring was capable of being read as retired sometime in the past, then there would have been no occasion to use renomination in the construction of the sentence. If the intention of law framers would have been not to permit a person to be member council for more than two terms in his lifetime, then a different, better, and stronger framing of the provision was expected. But now, having read to you what is a classic and I think extremely helpful illustration of plain language or literal meaning, let's see what he refers to as an authority in support, which is craze on statutory interpretation, because craze on statutory interpretation expounds what I just said, that ordinarily or prima facie we will follow this, but you can still look at other factors. And this is what craze says. The governing idea here is that if a statutory provision is intelligible in the context of ordinary language, the governing idea here is that if a statutory provision is intelligible in the context of ordinary language, it ought without more to be interpreted in accordance with the meaning an ordinary speaker of the language would ascribe to it as its obvious meaning. Now please note what follows. Unless there is sufficient reason for a different interpretation. Thus, an ordinary meaning or grammatical meaning does not imply that the judge attributes a meaning to the words of a statute independently. Please mark this. Does not attributes a meaning to the words of a statute independently of their context or of the purpose of the statute, but rather that he adopts a meaning which is appropriate in relation to the immediately obvious and unsearched context and purpose in and for which they are used, by unresearched, by enabling citizens and their advisors to rely on ordinary meanings. Unless notice is given to the contrary, the legislature contributes to legal certainty and predictability for citizens and to greater transparency in its own decisions, both of which are important values in a democratic society. The learned author cites three quotations from speeches of Lord Reed in the House of Lords, the gist whereof is, determining the meaning of any word or phrase in a statute, ask for the natural or ordinary meaning of the word or phrase in its context in the statute and follow the same unless the meaning leads to some result which cannot reasonably be supposed to have been the legislative intent. Rules of construction are our servants, not masters. A statutory provision cannot be assigned a meaning which it cannot reasonably bear. And then he goes on to explain purposive interpretation, which I will come to, but what's important is the holistic exercise that is carried out rather than a prioritization of rules or aids. And that you will find on the same page a little bit later on in the quote, where he says, the learned author states at another place that the rule of literal construction, whereby the words have to be assigned their natural and grammatical meaning, can be departed from, but subject to caution. The golden rule is that words of a statute must prima facie, please mark the words prima facie, be given their ordinary meaning. A departure is permissible if it can be shown that the legal context in which the words are used or the object of the statute in which they occur requires a different meaning. And then it goes on to explain the purposive rule, finding out the context of a legislation, etc. Now, that, my friends, is a good illustration of how the Supreme Court has approached the literal rule in two different ways, just to make the point before I move on. You will recall a short while ago, I cited to you a judgment in the case of Raghunath Rai Bareja, where the literal rule was applied in a conventional sense, in the sense of primacy, in the sense of indiscipline, don't look at anything else, a mandate. And then you will find another judgment of Harbajan Singh, certainly a part of the same era, 2007, and the Harbajan Singh judgment is, I'll tell you the year of that. The Harbajan Singh judgment is a judgment in 2002, where the literal rule is applied in a more balanced way, where there is a clear grammatical analysis, but then reference to authority to show that it's only prima facie and there evidently is room for departure. But I want to make a point over here, and this is a misconception, at least a misconception based on my understanding of the law as it stands today. And the misconception is that you can only deviate from the literal rule if the language of a statute is ambiguous. That is wrong. And that's precisely what Harbajan Singh in its various quotations and later judgments clarify. The room for deviation or the choices of various interpretations available to a judge would be more if the language of a statute is semantically or syntactically ambiguous, because then there's really everything, if I may use an expression, it's all open season, because the grammatical language is not helping you in discerning legislative intent. But that's not to say that that is the only time when there can be a departure or a deviation from the grammatical or plain meaning. And this judgment of Harbajan Singh is a bridge from literal to contextual and straddles both, but in that particular case talks about literal rule and plain meaning as being determinative of legislative intent. Two more judgments and then I will stop. I'll quickly run through two more judgments so I can complete the literal rule in its more balanced application, because it perhaps is a segue into what is really contextual understanding of a statute. Another interesting judgment, which many of you will be familiar with, is in the case of Nasli, Wadia versus Ivory properties. And this case, recently decided by the Supreme Court, put to rest a controversy that has really plagued the courts. And this is where lawyering does a disservice to itself or to the community. And the controversy over here involved the interpretation of section 9A of the CPC, which is a Maharashtra amendment. And 9A was a provision which was introduced in 1977 amendment to the CPC through Maharashtra amendment, which essentially says, and you'll all be familiar with it, for those who are not, it's quoted in my note, the paper. The provision of 9A essentially sought to do away with the mischief where parties were moving interim applications before a court for securing interim relief when the court clearly did not have jurisdiction to entertain the matter. So what was happening is that you would apply, get interim relief, and then for years on end sit on that interim relief whilst the question of jurisdiction was being decided. So to curb that evil, and that's the preamble. Example that was given was, for example, when you file a suit against the Union of India, you need to, under section 80, give prior notice to the Union of India, and people would apply, get ad interim relief and say that I can't give notice because of urgency, secure the ad interim relief, and then for years on end sit on it only for it to be determined many years later that the suit could never have been entertained in the first place because the jurisdictional requirement of prior notice was not fulfilled, or under 527 to the MCGM, just as illustrations. So 9A was meant to curb that. And it was meant to curb that by saying that when you are applying for interim release and a jurisdictional objection is raised before the court will not entertain the application for interim relief till it decides the question of jurisdiction. That's in sum and substance what 9A said. And the language used in 9A was that an objection to the jurisdiction of the court to entertain such a suit is taken by any of the parties, the court shall proceed to determine at the hearing of such application the issue as to jurisdiction as a preliminary issue. Now, this solution to a problem became much larger than the problem itself. And what started happening then was that plaintiffs would apply for interim reliefs. Sometimes they would get ad interim, sometimes they would not. And defendants would raise many defenses in the guise of a jurisdictional objection and then tell the court, sorry, you cannot move further with the application for interim relief till such time as the jurisdictional objection is decided. That you have to decide, and that's the mandate of 9A. And the law went so far as to say that since it means decision of a jurisdictional objection, if that jurisdictional objection is a question of fact and law, it requires a mini trial. So the judgment of Mayor Singh of the Bombay High Court said evidence can be led to decide the jurisdictional objection. One of the most common misuses of 9A then became defendants raising the question of limitation as a jurisdictional objection, as a jurisdictional objection to entertain the suit. And many times courts simply could not proceed further with the hearing of an interim application because the law said decide jurisdictional objection first. And all of this wended its way to the Supreme Court, where the Supreme Court had to then consider what are the jurisdictional objections contemplated by 9A. Did it contemplate an objection which involves perhaps questions of fact and law? Or did it contemplate the more narrow meaning of the word jurisdiction? That is, jurisdiction to even set foot into a matter, for a court to even entertain a matter, to even take cognizance of a matter. So there are different meanings of the word jurisdiction. The one view taken by the Supreme Court in the case of Salunke was that jurisdiction here meant narrow, nothing more. Jurisdiction is only jurisdiction to entertain the suit. It does not include jurisdiction in the wider sense of limitation or some such objection, Benami Act, etc. Whereas the wider meaning was that jurisdiction includes limitation, because if you find that a suit is time barred, then there is a mandate under Section 3 that the court will go no further into the merits of the matter and will dismiss the suit on limitation. And ultimately, the Supreme Court, by applying a more literal approach in the three-judge bench of Nasli, Wadia versus Ivory properties, said, after looking at all the various meanings, said, look, let's look at the plain language of 9A. And it did look at legislative history, it looked at legislative background, it compared 9A to other provisions of the CPC like Order 14. But ultimately, in its own way, without discounting the importance of all of that, said, plain language, the words are made in any suit an objection to the jurisdiction of the court to entertain such a suit. So the Supreme Court finally said, jurisdiction may be a word of many colors, but we have a qualifying expression, and the qualifying expression is to entertain such a suit. Therefore, in the context of 9A, there can be no doubt that jurisdiction means threshold and not a jurisdictional inquiry which may require some examination of the merits. You have to bring this within the threshold. If it is not a threshold jurisdictional objection, then 9A has no application. It was never intended for the wider meaning of the word jurisdiction. So that judgment again is something which you should read, and the relevant paragraphs, which I'm not reading to you right now, but are paragraphs 27 and 28, which in your own time you should read, on how the Supreme Court unraveled the meaning of 9A, which for 15 years has been such a bottleneck in our court and in our system. And I'll end now for today's session with one last judgment and then one anecdote on the application of the plain meaning to a commercial matter, whilst taking into consideration other factors. And this is a matter which I had occasion to be involved in concerning the Commercial Courts Act. Now, as many of you would know, that the Commercial Courts Act was enacted with the very salutary objective of expediting commercial suits. And one way of doing that was by fixing a very stringent timeline of 120 days on the outer side for filing of written statements. And unlike Order 8 of the CPC, Order 8.5 and 8.10 of the CPC, perhaps Order 8.1, 5 and 10 of the CPC, before the Commercial Courts Act, where the Supreme Court in Kailash versus Nanku took the view that the word shall file within 30 days and to be extended by whatever it is not mandatory, that the word shall must be read as may, which means that under the CPC, although the intention was a mandatory period of 30 days to file a written statement, it was interpreted to mean directory and not mandatory. The Commercial Courts Act put in language to really, in a sense, overturn those consequences, to say that you shall file it within an outer limit of 120 days, that is 30 plus 90. And if you don't file it within that period of time, then your right to file it is completely lost, with no way back in. Now, in the lead matter of Axis Bank, an argument was made before Justice Kathawala at great length on whether there are some exceptions where you can file your written statement after 120 days, and provisions of the CPC were analyzed to say what happens if on the 117th to the 120th day we're in the midst of a pandemic and nobody can reach the High Court registry, etc., etc., etc. But Justice Kathawala said that for all suits governed by suits filed after the Commercial Courts Act ordinance, or the ordinance came into force and then the act came into force, this 120 days is 120 days, it's sacrosanct. That's the meaning and that's the intent of the legislature, whatever the hardship may be. And I'll come to hardships and absurdities in the next lecture. You will follow it. There was a sequel to that matter, which is a matter that I was involved in. And the sequel to that matter was what applies to suits that were filed before the Commercial Courts Act was enacted, but which were transferred to the commercial courts list and to be now treated as commercial court suits. And I was appearing for the defendant, and there had been various timelines given to the defendant for filing a written statement, which he had not followed. But my argument was that the plain language of the Commercial Courts Act in section 15.4 and the proviso to it carves out an exception to transferred suits. It does not treat transferred suits on the same plane or as it would treat a suit filed after the act came into force. And I said, if you look at the plain language, it's very clear. The plain language says that the relevant provisions of the CPC, the amended provisions which fix an absolute time limit, shall not apply to a transferred suit or application, and the court may, in its direction, prescribe a new time period within which the written statement shall be filed. So you will find the proviso. So that's really the language. And I was conscious of the fact that what I'm arguing is against perhaps the purport of the Commercial Courts Act, which is to speed up all suits, not just new suits. And that's really how the earlier matter had been decided. But my argument was that the legislature, being conscious of the distinction between old suits and new suits, has clearly said that old suits which are transferred are not subject to the same stringent time limit and the court may in its discretion prescribe a new time period. It really, for me, it didn't admit of much debate, and fortunately the court also saw it that way. But this was a case where I've put it in my note, that the entire argument on the other side was an attempt to defeat the plain language by saying that look at the purpose of the Commercial Courts Act. Chapter and verse, it talks about expediting suits. Would you not be defeating that legislative purpose if you followed the plain script, which is that for old suits which are converted, this time period does not apply? For Justice Kathawala, this matter is pending in appeal. It's been admitted, but there is no stay. And Justice Kathawala, in his reasoning, was conscious of those factors, but still said that the legislative intent is borne out by the plain language. And he also said one more thing, which is very important, which is that if you don't go by the plain language, then what is the starting point of the 120 days for a transferred suit? And he asked that question and was not getting a clear answer, and there was no clear answer, and that was yet one more indication why we must go with the plain language. So this is where I will stop my case law analysis for today. But I'm going to end with, since we've spoken so much about words, their meaning, their context, and the play on words, I wanted to end with an anecdote, which is based on a forward that I received from my cousin Rishika, who's also a lawyer and in the same chambers that I am. And it was recently received by me, and I found it very amusing. So yes, the source is WhatsApp University, but whether it's true or not is hardly the point. It's still relevant. And there was a competition on what is the most novel or ingenious criminal lawyer in America. And the presenter presented the award to an entry which came in from, I can't remember, from North Carolina. And it was an individual practitioner. And he then gave details on why this was most ingenious example of criminal lawyering. And the reason why the award went to this particular gentleman is because the lawyer was himself a litigant in a case against an insurance company. And the case involved an insurance policy that the lawyer had bought in respect of 24 Cuban cigars, and he insured them against loss or destruction by fire. And the lawyer then smoked the 24 Cuban cigars by lighting them, as anyone would, and that's the only way of doing it, and lighting them with a fire, smoked them, consumed them as a commodity. They didn't exist anymore. And he then filed a claim with the insurance company saying, my policy says that I'm entitled. Then he insured them for $15,000. And he said that my policy says that it's insured against fire. Plain meaning, you can't go behind the policy. You can't try and understand what it means. I've smoked them. I've lit a fire. Please pay over the insurance money to me. And the insurance company, of course, argued fire surely can't mean this, can't mean that. But the judge held in favor of the lawyer, said that as much as it was against his instinct or against his desire, he said the policy is very clear that these have been lost to a fire, and hence I'm allowing the insurance claim for $15,000 to the lawyer who has smoked his own Cuban cigars. But the matter didn't rest over there, or it did not end over there. And immediately after the verdict came down, the insurance company made sure that the very same lawyer was indicted on the charge of arson because he lit a fire. So that's really where I think that the words fire, or this example, really brings to life the various dimensions that can be brought to play when we understand words, or we explain words, or we construe words.